Hello, hello. This is Attorney Mike Gravel coming to you from Chicago. As usual, we got fun stuff sent to me by the usual suspects. We got, who? Natalie D's involved. Kristen Trowcity's involved. A lot of good stuff. The Discord suggestion people are involved. They're all complicit in this deal. It's good. Let's check it out, shall we?
Are you working someplace?
I have a couple of job interviews lined up for today and tomorrow.
How long have you been out of the hospital?
About 2 months. 2 months.
Everybody seems to have a job interview lined up today or tomorrow. I'm not sure how that works.
You don't know what to say to that, do you? All right.
Morning, I'm Referee Pachorka. We'll go ahead and get started. Looks like this is file number 98-000-338-DM. Looks like we have both parties here. Mr. Rogers, I have to advise you before we get started that you have the right to...
You're going to love this referee. Is it Pekiorka? I can't remember. He just said his name. He's fantastic. He's having none of it.
Request a court-appointed attorney. If you make that request, we will postpone today's hearing to give you time to speak with your counsel. And Mr. Rogers, are you requesting court-appointed counsel today?
I appreciate your question, but I'm not interested.
All right, then. Ms. Mullen, if you would please call the case.
Thank you. This is a matter of Mary Orman, now known as Maciage versus John Rogers. And this is an arrears only case. Since April of 2015, there were 2 children between the parties. The balance currently owed on the account is $25,000.
Your Honor, I object.
All right, Mr. Rogers, what would you like to say in response to today's show cause?
I'm here by special appearance to object to this court's jurisdiction.
Objection. All objections.
I filed 3 sets of paperwork 2 weeks ago. Are you in receipt of them, and are they on the record for the record?
The court will take notice of your filings, Mr. Rogers, and would you like to address any of the points from those objections that you filed at this time?
I'm here as special appearance only, Your Honor, to object to this court's jurisdiction. Unless
why does the court not have jurisdiction over you today?
I appreciate your question, Your Honor, but I'm not interested.
Okay, very well then. At this point, the court finds that it does have jurisdiction over the payer. The relevant statute is, for the purpose of the show cause, is MCL 552.633.
Your Honor, I object. The state of Michigan has not entered any evidence to prove that they have jurisdiction.
Under subsection 3, in the absence of proof to the contrary introduced by the payer, the court shall presume that the payer has currently available resources equal to 1 month of payments under the support order. This is an arrears only case. However, when this case was in payment status, what was the monthly payment amount, Ms. Mullen?
The charge was $303 per month.
The state of Michigan has not entered any evidence that there is such a debt. They have not entered any evidence that they have jurisdiction.
Ms. Mullen, what was the dollar amount?
$303 per month, Your Honor.
All right. In that case, the court finds, based under the statute and the absence of proof offered by Mr. Rogers, that he has the ability to pay support of
Your Honor, my evidence is on the record, and you're not observing it.
$333 per month. Therefore,
I do not consent.
The court does find that Mr. Rogers is in contempt. He will be placed on probation for a period of 2 years.
I do not consent to that.
During that 2-year period, he will make payments according to a payment plan consisting of $333 per month. If he does not make payments according to that plan, a bench warrant will issue for his arrest. The amount of the bond will be set at $1,000, which he will have to pay or serve 5 days in jail.
Your Honor, you haven't addressed the jurisdiction of this court yet.
Court is in recess. Thank you.
Thank you.
Are you a Mr. Matthews?
Yes, sir.
Okay, I poached this from Rebel Chaser. Link to the original video in the description below, and also to the channel. It's fantastic.
Your name is Nitraven Matthews, spelled Nytravin. Middle name Maute. Last name Matthews. Is that
Nitraven cannot shut his hole.
all
Yes, sir.
correct?
Yes, sir.
You're charged with a Class B misdemeanor offense of criminal trespass. If the state can prove their case, maximum punishment is 180 days in jail up to a $2,000 fine or some combination of fine and confinement. Because you find yourself charged by the state of Texas, you're absolutely entitled to be represented by a lawyer. You can hire a lawyer or you can have one court appointed. What would you like to do? Would you
Yes,
like
sir.
to,
I'm sorry. Can I ask a question?
after I'm done,
Oh, okay, I'm sorry. Go ahead.
what would you like to do? Are you going to hire a lawyer or do you want one court appointed?
You know, I had a question. I was wondering, like, if you said, now, what was the charge again?
Class B misdemeanor criminal trespass.
Okay, if it was just trespassing, would I be able to get time served on that if I was saying, because I didn't mean to walk up on the grounds, but there was an accident?
If you said you didn't mean to walk upon the grounds, that means you are innocent.
I know that, but like, but I would
Sir,
rather.
you cannot talk when I'm talking.
I'm sorry, sir.
If you say you did it on an accident, you are not guilty, and the prosecutor, who is the one who makes these offers, would relay an offer in exchange for your guilty plea. You just told me you're not guilty.
No,
There we go.
I'm
Sir,
sorry.
you really cannot interrupt me. Ergo, she cannot make an offer to you.
No, I wasn't going to say I'm not guilty. I was going to say I'm guilty. That's what I was trying to say.
You said you walked up on accident. That's the mens rea,
No.
the middle element, which means
wasn't-
that, sir, we're done. You're excused.
No, I'm not. I wasn't done talking. That's what I was saying.
Stop talking about your case, please.
I'm trying to tell you, I meant to have walked up on the property. I did walk up on the property. I was guilty, but you wouldn't let me say it. You were trying to say that, but you didn't let me say that yet.
Not what you said. You said you walked up on accident. You're excused.
Yeah.
No, I wasn't done talking. I said my mom's went crazy, and I just walked up because I thought somebody called me over there. I wasn't ready to. I wasn't sitting to say the whole sentence. I'm sorry.
Good. Are you done talking?
Yes, sir.
You're excused.
So I don't get a plea bargain or nothing.
Not today. Not in front of this judge.
Oh, it doesn't stop him.
Did it on purpose. I'm
sorry.
I'm sorry. Here's Franklin real quick.
I'm not going to lose my law license on YouTube Live.
He said, when I just told him I wasn't guilty, I said, I was trying to explain him why I thought I was the whole thing was, oh my God. Well, no, I'm still being explained if I'm guilty or whether not guilty.
Would the next person please approach?
Because right now, I'm not going to explain. I walk on there, but I'm guilty. I walk on there, so I'm saying I'm guilty. I am guilty. I was starting to say that. Why didn't you say now being like 5 months?
Do you blame him?
Why? That makes no sense.
I'd be dealing out contempt.
I'm sorry.
So can you tell me how long I'll be here now? Well, I'll start a phone with everybody, including you.
Let me see if I can make the other side of the problem.
Right now.
No, he's not.
No, that would be 5 months now while I talk to the judge. That right there was unfair. That was the problem.
Do you want us to call 911?
I'm glad you're here. That was for property, but he just did. He didn't even let me tell him if I was guilty or not guilty. No, I'm not. Well, he didn't let me tell him I was guilty or not guilty. Now I have to be here for 5 freaking months because he didn't freaking sit there and listen to me say I was guilty. The whole story. Okay. No, but I'm saying watch. Because then how you take me back to the jail cell and say what's for the next grade, which is 5 months down from now, and he didn't even let me say if I was guilty or not guilty.
And heard that he wasn't guilty, so we won't listen to
No, and he didn't let me say so. No, I was explaining to him I was done saying guilty or not guilty. That's what I was trying to say. He freaking cut me off and said that shit. So it's not pretty fair. So now, so like, what the fuck do you figure out this whole
City of Royal Oak versus Lawrence Dejan Nicholson. Your appearance, please.
Oh, this is another good one. We've got grown up Harry Potter judge here. He was the guy who cut the guy a break on the Moody Blues guy a break. We're gonna see him too.
Morning, Your Honor. Stephen Lynch on behalf of the defendant for today's arraignment via Zoom. We consent to same. For purposes of the arraignment as to the charge of drunken disorderly, we waive the formal reading, stand mute to the charges.
Thank you very much. I'm sorry, Mr. Lynch, but I will hasten to call a second matter now. That is 22 RO06320. That is people of the City of Royal Oak. Also versus Lawrence Deshawn Nicholson. Mr. Lynch, this one is a bench warrant. The original charge was scavenging, transportation of refuse, and
this guy's cool. He's gonna
Mr. Nicholson had failed to appear last April the 3rd, so that one had a bond set of $2,500 cash surety or 10%. There had been an original arraignment. As to that one, you're moving to have the bench warrant set aside?
I am, Judge. My client did ask me about the scavenging. Now I understand because I kept saying it was only one count. So now we know there's a second file. I just asked that they both be set together for pretrial on the same date.
Very well. So the Zoom consent is noted as to both. Bench warrant is recalled. Not guilty pleas are affirmed. Court appointed counsel noted and approved. Mr. Nicholson.
Yes, sir.
Oh, now they're handing me a third file. Okay, Mr. Nicholson. I'm also going to call this one Mr. Lynch. 21 RO00546.
It's about to get worse.
546A. Yet again, people of the City of Royal Oak versus Lawrence Dejan Nicholson. Again, Mr. Lynch, for your information, this one is a littering charge. Mr. Nicholson failed to appear for his pretrial that was to have occurred on January the 3rd, so bench warrant issued on February 2nd, and here we are today. And again, that one had already been arraigned, so I can simply reaffirm the plea of not guilty as well. So you're moving to set aside the bench warrant on the third file.
Please, Judge. Are we going to have a fourth, or are we done at this point?
I think we're 3 for 3. Mr. Nicholson, how you doing?
I'm trying to make it, sir.
All right.
The defendant's got a big old smile on his face. The attorney's like, I come in here with one charge. Now we're up to 3. What else? What else, Judge?
You're causing a lot of energy and activity in a short period of time. The reason we took all your contact information down, Mr. Nicholson, is these matters get way more complicated when we ignore them or we don't show up to court. So your contact information is critical. You need to pay attention to that mailbox. You need to pay attention to your phone. Prior to your next court date, you're going to get a notice. It's going to direct you as when and where to appear. You need to do that. All right? And prior to that hearing, you'll be hearing from an attorney, which may or may not be Mr. Lynch or somebody similarly highly skilled. That attorney will do their best to team up with you so you can together act in your best interest. However, they can't help you if you don't do the very minimum by helping them and responding. Okay?
All right.
That being said, Mr. Lynch, what are your remarks as to bond?
Judge, although there are 3 cases, my client is here today timely for this one. He walked in to address the most recent. At least he had been arraigned on the other 2. I'm asking that all 3 be set for pretrial. All 3 are non-assaultive. On the grand scheme of things, not trying to minimize, but they are on the low level of seriousness in the things that we look at day in, day out. I'm asking for a personal bond. He's not on probation or parole.
Okay.
He is employed at Leo's also.
Where is Mr. Nicholson employed?
Leo's.
Leo's. Okay.
Yes.
And does he stay at Eureka, or is that a mail drop?
I believe he stays there.
Okay. Is Mr. Nicholson treating with any healthcare professionals?
Not that I'm aware of, Judge.
Mr. Nicholson, do you see a doctor on a regular basis?
Yeah, Belmont.
Do you perhaps have an Easter Seals worker?
No.
No? And what does Dr. Belmont do for you?
They gave me some Abilify.
And are you taking it?
Yeah, no, they recalled it because it poisoned me.
It's poison?
Yes.
Okay.
I'll see the doctor at the bar.
You see the doctor tomorrow?
At the bar.
At the bar?
Yeah, I saw him at the bar.
Okay. The court is going to order as follows. On all three of these matters, the court is setting a $2,500 personal bond. So that's a total of $7,500 in personal bonds. That means you don't need to post $7,500, Mr. Nicholson, unless and until you start missing court dates again.
All right.
If that were to occur, you're going to owe the court $2,500 personal, or cash money, I should say, on each file. And a bench warrant could issue for your arrest, and you could end up sitting in stir until you get these cases resolved. I don't think you want that. Mr. Lynch doesn't want it. The court doesn't want it, okay? We're doing our best to try to help you, but we're acting in good faith. We simply ask you to do the same thing. We're providing you with as much fairness as you're absolutely entitled to under the Constitution of the United States and the state of Michigan, sir.
You need a while.
That said, there's also to be no use of alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician. So if you have a valid prescription from a treating physician, whether or not you see that physician in the bar, if you have a valid prescription for a psychotropic medication, which might be a good idea, you're to take it. And you're to take it legally. If you're taking any controlled substance that you don't have a prescription for, that could be a violation of your bond, and we're back to talking about jail and $7,500 in bonds. Okay? So you need to keep an eye on that mailbox, sir. This may be your last bite at the personal bond apple. Do you have any questions?
No.
All right. That completes your arraignment. Mr. Lynch, anything further?
No, Judge.
Thank you so much. I appreciate that. And he is gone.
Yep. Come online with the phone number that ends, the last four digits are 1822. What is your name?
Okay, so Harry Potter judge, who was just on earlier, let this guy go like yesterday or the day before on a parking ticket, and he's back in front of a different judge with the same song and dance.
Name, please. Phone. Last four digits of the phone number, 1822. What is your name?
Ricardo Lopez.
Okay. Got a parking ticket?
I do. I think I got the live feed for the Zoom, but I'm not.
Are you on more than one device?
I don't know. I finally got the. Hello?
Mr. Lucas, how many devices are you operating on?
Okay, I called on the phone, but I think I got the court room with the judge there now. But should I just leave on the phone, or I don't know what to do?
Well, I'm not seeing that you're
Well, it says Kiara Wilson, because
No, it says Samsung.
Huh?
What brand phone do you have?
I got an AT&T phone.
Okay, let's just stay. We'll stay with the phone.
I'm coming around to this guy's just doing this. It's like a Jerky Boy skit. Like I have an AT&T phone. Come on. I think he's. I don't know. I shouldn't say.
Connection that we had.
Okay,
The allegation here is that on the 10th of April,
I believe it
you
is.
were parked for 6 minutes and 14 seconds on Lafayette.
Right.
You didn't pay. Do you remember what happened?
Yeah, I tried to put the quarters in, and they kept on popping out, and then I saw the card thing, and I swiped it. Then I found out that my card was a chip thing, and
Yeah, we've heard this
I
before.
basically had to slip in the chip, but I didn't realize it, and I scanned it, and probably didn't register for that too. But anyways, I was there for 6 minutes, and I was trying to go around the corner, which is right there on the corner for Royal Oak Music Theater, and then I went over there. This was on a Monday, and I found out they're closed. They don't open until Tuesday from 12 to 6 or something like that. But anyways, this was a Monday, and obviously they're not open, so I can get my tickets. So I wasted my time, and I couldn't put no money or didn't do my credit card right for those meters, and so obviously, how can you pay when you don't know how to?
Well, the good news here is that they changed the rules after you got this ticket, and now you would have had up to 15 minutes instead of just 5. So if you would have had this happen a couple weeks later, you would not have gotten a ticket.
Oh, okay. I know they had that court thing or something, and they...
Oh, this wasn't in court. This is the negotiation City did with the company that runs it.
Oh, okay.
So what we're going to do here today, what happened, but I am going to waive the fine and the cost.
Okay, are you the judge?
Yeah.
Oh, you're the judge. I think I may have found the Zoom, how to do the Zoom,
Yeah.
but then I didn't.
Yeah, that's why he's got the robe on and all that.
All of a sudden you called up and I'm saying, okay, I think I'm in. But okay, so you got to waive the cost down to 6 minutes then?
Yep.
Okay,
No,
thank you, sir.
You're good to go, sir.
Okay, have a nice day.
You
Thank
too.
you. Bye.
Bye.
Felony information. You can go ahead, Mr. Stay.
Your Honor, I filed this about 6 weeks ago.
It's a little longer.
Preliminary examination was held where the date of February 12th, 2023 was demonstrated. For whatever reason, the information indicated February 12th, 2022, so I'm asking for leave of the court to file amended information.
Ms. Frisbee?
No objection to the motion, Your Honor. My client is
All right, so the court is going to grant the motion to file an amended information in this case. The amended information is consistent with the testimony at the preliminary examination. There's no surprise to the defense. And so the court has received a copy of the amended felony information.
That was the year that was.
All right, we're also here for a final status conference. Is there a final offer that you're making in this case, Mr. Stay?
For the defendant to enter a guilty plea to count 1, people dismiss the balance of the information. Guidelines 0 to 11 months on the minimum. People cap at 6 months.
Ms. Frisbee, is that the offer as you understand it?
Yes, Your Honor.
Did you have an opportunity to discuss it with Mr. Peterson?
I have.
Is that correct, Mr. Peterson?
Yes, sir.
All right. And Ms. Frisbee, does your client wish to take advantage of that agreement?
No, Your Honor.
Is that correct, Mr. Peterson?
Yes, sir.
All right. Do you understand that this agreement would call for you to plead to fleeing, eluding a police officer in the 4th degree, a 2-year felony. Mr. Peterson, you understand that this agreement would call for you to plead guilty to fleeing, eluding in the 4th degree. It's a 2-year felony.
That's if I accept the agreement, that's what I'm pleading to another.
Yes.
Yes, I agree. I understand. Yes, sir.
In exchange for a plea to that count, they're dismissing an operating license suspended second offense. That's a 1-year misdemeanor. You understand that?
Yes.
Well,
They're also dismissing the habitual offender second, which
But it
has the
takes time.
possibility of increasing your advisory guidelines and also has a possibility of increasing the maximum penalty from 2 years to 3 years. Do you understand that?
Yes.
All right. This agreement puts a cap of any incarceration at 6 months. That means that you can get anywhere from 0. You're not listening to me, sir.
I'm sorry. I'm trying to discuss. Sorry.
So you understand that this agreement has a cap of 6 months, which means that if you were to accept this plea, you could get anywhere from time served up to 6 months. Do you understand that?
Yes, sir.
And you would also be consenting to a term of probation. You understand that?
Yes, sir.
Whereas if you go to trial and are found guilty on the misdemeanor, you could get up to a year in county jail. Or on this felony offense, you could be looking at, if I follow the advisory guidelines, you could be looking at up to 11 months. You understand that?
Yes, sir.
You have a chance to resolve the case today for agreement for no more than 6 months. Do you understand that?
Yes, sir.
You've gone over all that with your lawyer, is that right?
Yes, sir.
All right. And you're rejecting that offer.
Well, that's what I was discussing with her. I didn't understand it at first, but as talking with her, can I talk with her for a split second here, just to kind of make sure that we're on the same page here?
Okay.
I'll accept it.
All right, Mr. Peterson, would you raise your right hand, please? Do you solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
You can put your hand down. So the charge that you're entering a guilty plea to reads as follows. On or about February 12, 2022, that you were in Bridgeton Township, Nuevo County, State of Michigan, that you committed the crime of fleeing and eluding a police officer in the 4th degree, that you were the driver of a motor vehicle who was given a visual or audible or signal by hand, voice, emergency light, or siren by Brad Howard, a police officer who was in uniform and whose vehicle was officially identified as an official police vehicle and who was acting in lawful performance of his duty, directed you to bring your motor vehicle to a stop, and that you did willfully fail to obey that direction by either increasing the speed of the motor vehicle or attempting to flee and elude the officer. This is a felony which carries up to 2 years in prison and or $500 fine plus cost, and the Secretary of State shall suspend your license for 1 year. Do you understand the charge and the maximum penalty?
Yes, sir.
We've been over the plea agreement in this case. Is that your understanding of the plea agreement?
Yes, sir.
And subject to the plea agreement, how do you wish to plead?
Yes, sir.
You understand that if I accept your guilty plea, that you're giving up your right to have a trial of any kind?
Yes, sir.
You also understand that you're giving up some certain constitutional rights and other rights you would have if you went to a trial?
Yes, sir.
We've listed those rights for you on a written advice and rights sheet. Did you read that document?
Yes, sir.
Did you understand those rights?
Yes, sir.
Has anyone threatened you to get you to make this plea?
No, sir.
Has anyone promised you an outcome different than what we've put on the record?
No, sir.
You're entering this plea of your own free will.
Yes, sir.
You understand that if I accept your guilty plea, you're giving up the right to later claim that it wasn't your choice to make this plea, or the plea was resulting in promises, threats, or inducements that you don't tell me about today.
Yes, sir.
Judge is like,
You
yeah.
understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your. Do you now give up your right to have a trial of any kind and all the constitutional rights and other rights you would have if you went to trial? And do you affirm you're guilty?
Yes, sir.
Is it true then that back on February 12th, 2022, that you were in Bridgeton Township, Nuevo County, state of Michigan?
Yes, sir.
Were you operating a motor vehicle on 112th Street?
Yes, sir.
And did you have an encounter with a Michigan State Police trooper?
Yes, sir.
Did that trooper do something to signal to you that he wanted you to pull over?
Yes, sir.
What did he do?
I guess he kind of pulled up in front of me. I mean, he wasn't behind me or nothing, lights or sirens on or anything going, but I went down the road and came back out and he came up right here and I went to go this way. And I mean, that's the only encounter we had. And then I got arrested.
So you were going down a dirt road and
I was going on Maple Island. I turned right onto a road. It was
stop you there. Did you turn on that road because you saw the trooper and you were trying to get away from him?
No, I didn't know where I was going. I didn't even know the road.
So you turned down that road, correct?
Yes.
Dirt road off
Yes,
Maple Island. Trooper turns down there and it sounds like he pulled this vehicle across the lane of traffic. Is that right?
Well, he didn't know where I was. I guess he was whatever. I don't know. And then I come out because it was a dirt dead end and was to go back out to the main road. And he was coming in this way and stopped right there.
And he stopped on the dirt road, blocking your passage?
Yes, sir.
Okay. Did he have his lights on in the vehicle?
Not at the moment, no, sir.
All right. At some point, did he turn them on?
When I went to go the other way, he turned it on. That's when everything stopped.
So you went. So he blocks your path of travel.
Yes, sir.
You go around his vehicle. Is that right? Yes or no? You went around his car.
No, I didn't go. I didn't go around his car. When his light came on, I stopped my vehicle.
I hadn't got there yet. So he's blocking your road. He's blocking the road. You go around his vehicle at that point. Yes.
No, sir. I was coming back out the dirt road. It was a dirt road that dead end into a driveway. I come out of the driveway. He was coming down the dirt road that was dead end to the driveway. When he came here, he was pulling up this way. I was coming out this way. He pulls up here. I go this way. He turns his light on. I stop the vehicle.
All right. So you went around his car.
Yes, I didn't. But you said that I went.
I asked you 3 times. You went around his car.
I apologize.
All right. So then you go around his car. Then he turns on the lights. Right?
Yes, sir.
Did you stop immediately?
Yes, sir. I stopped and got out.
How far did you travel before you stopped?
10 feet.
Right. Any more to the story, Mr. State?
This is a felony evading charge, remember.
The defendant turned off the road into the officer found. His lights were on, trying to make it clear again. Towards the end of a very tight, dirt road type thing. And the defendant turned around, the officer got out of the car and verbally told him to stop. I can't recall from meeting this, but it was with his hand as well. And the defendant went around him. And the reason why he stopped was he got stuck in the ditch. It was very quickly, but he did attempt to go around the officer.
All right, so was the officer out of his car giving you some sort of signal by his hand to say stop?
Not until after I got out of my vehicle, he got out of his. That's what happened. And the thing comes in is that he explained to me and my wife that was present of the day that there's no way he can charge me with, there's no plea or nothing because he didn't have his lights and sirens active. He didn't have anything. He didn't even know where I was. So I don't understand what the whole light and siren thing is or whatever, but there was no lights and sirens active. And it was told right.
So did you, when his vehicle is parked across this small dirt road, did you see him do any gesture with his hand or anything signaling to you to stop your car?
No, sir.
All right. So then you go around his vehicle and then he turns on the lights. Let me see if I'm understanding it. Because you've told me and I didn't understand what you were saying. Okay. So you go around his vehicle. He then turns on the lights and Did you get stuck in the ditch and that's what stopped you?
Yes, but it was slippery, and when I didn't know what was going on until the light came on, he never blocked the road. I was in a driveway coming out to the dirt road that was dead end. He was still on the dirt road that was dead end and pulling up to pass the driveway, and he seen me. And that's when we kind of came right here. But when I seen him right here, I went off to the side here. He moved up a little bit forward, hit his light on. He didn't get out of his truck until I got out of mine. And then I went right up to him.
That's not the testimony at preliminary examination. Had his lights on, got down there, defendant tries to turn around or has turned around, officer's down there with his lights on, gets out of the car, either by hand and certainly by voice as well, tells him to stop. It's very clear in the officer's testimony. Defendant turned his wheel and tried to get around it, but got stuck.
Mr. Peterson, do you accept that rendition that the prosecutor just said as the testimony that was at the preliminary examination?
What was said in court wasn't what was said at first, and what was said by him actually to me and my wife, that he did not have his lights and sirens activated. He did not have any. He didn't even know where I was. He was whatever. I don't know what or why I don't know. But
he lied under oath at the preliminary examination.
And I'm gonna say,
I'm not taking your plea. You go to trial this.
Okay.
I don't want you pleading guilty to something that you didn't do. And what you're telling me doesn't sound like it doesn't sound like you think you're guilty of anything. And I guess we'll let the jury decide. You can hear the officer's version, and then you can testify or not, and they can sort it out. Okay.
I just didn't see that coming. The judge is like, I'm not accepting this plea. Given your version, you're not guilty of it. And the judge is correct. I don't know if you're right or the cop's right. I don't know, but we need to have testimony on this issue. You're not pleading guilty to the offense, and the offense is a felony. I get it. I think it's the right call.
William Stedman versus Ken Green.
This is kind of fun.
And yeah, do we have William Stedman?
Yes, sir.
State your name, please.
William Dwayne Stedman.
Do we have Mr. Green?
Yes, sir.
State your name.
Kenneth Green.
All right. Okay, Mr. Stedman, we have Mr. Green here. You guys want to go to a breakout room to discuss this matter?
No, I do not.
Do you have an agreement as to what we're going to do here today between you and Mr. Green?
There is no agreement except for he's to leave my premises, my property.
Okay.
I have no...
All right, we'll set the matter for trial. When you do come to trial, make sure you bring all the documentation you need to establish your rights, both as the landlord and as the tenant. Okay. You can choose, Mr. Stedman and Mr. Green. You can leave the court. We'll send out notice.
Thank you.
You're welcome. Chelsea
Why would there have...
Azul.
Sir.
I'm sorry?
Yes, well, I'm just wondering why there'd have to be a trial when there's no...
Well, you said, Mr. Stedman,
Why would there have to be a trial? I know the audio isn't great on this one. He asked the judge, why would there have to be a trial? Well, the judge asked, do you have an agreement, or do you want to talk to each other? No. Okay, that's a trial.
Mr. Stedman, you indicated that you didn't want to talk to him. And then you said you don't have an agreement, so that's what we need to do. We have to set the matter for trial because there's two different positions here. So we need to sort that out at a trial so that everybody has their complete right ability to state their case on the record. Okay.
Not really, but I guess that's the way it's going to have to go. But yeah.
Well, I mean, I'm sure you want to be able to state your full case, and so does the defendant. So everybody has a right to do that, and then I'm going to make a decision. Okay.
Well, all right, but I just
give me that
don't
way
know
about
why there would be any disagreements with the landowner and.
Okay, but that's what we'll see at the trial time. You might be right, but there might be some defenses that Mr. Green will demonstrate to us, and we'll have to decide it at that time. Okay.
All right, sir. Thank you.
All right. Good luck to you.
Okay, you bet.
All right.
Bye.
Bye.
All right, we've got a bonus Harry Potter judge clip. I really need to learn the guy's name, but you know, he only came into my consciousness like yesterday. I guess it's William Urich.
Is case number 23 R02790. It is people of the city of Royal Oak versus Shaquille Hamid. That is you.
Yes, sir.
Mr. Hamid, my name is Magistrate William Urich. This is the date and time the court set to honor your request for an informal hearing, and an informal hearing is just that. This is not a criminal proceeding. There's no custodial consequence. Nobody's going to jail today on their ticket, okay?
Yes.
With that being said, you will be required, Mr. Hamid, in the protection of your own rights to make a selection from one of three distinct options. You have the option, should you wish, to simply admit responsibility to this matter. The court will assess a fine per schedule, and that will close the case. You also have the option, Mr. Hamid, to admit responsibility with an explanation. When the court, and it frequently does, sees offenses of this nature, often the motorist has remediated, fixed, so to speak, the situation, and they might have an updated registration certificate. I don't know that yet, but that's a possibility. Your third option, of course, is to deny responsibility. That might look more like an episode of Law and Order. In that circumstance, we will swear both parties in. The who testifies first to say bear the burden of proof. It would then be your turn to testify, tell the court anything you want to know. So essentially, you'd be stating under oath that the plates were actually valid at that time. So the court would hear you out. You may display any exhibits you might have, and then the court would have to make a finding of responsible or not responsible based upon the civil burden of proof, which is a preponderance of the evidence, or what the law professors refer to as the featherweight test. So with that being said, you may admit with an explanation, or deny. What would you have the court do for you today, sir?
I will admit with an explanation, Your Honor. Yeah.
Okay, so you're admitting to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak upon which the registration plate had expired. Is that correct?
Yes, sir.
The court accepts your plea of responsible. It looks like you're brandishing a piece of paperwork.
I have, this is, so I renewed, so it was under my brother's name, the vehicle, and I was heading to work in the morning, right? So I'm just driving early in the morning, heading to work. The cop was on the roadside, right? So
police officer?
Yeah. He was on the road sitting. I go past him, boom, the blue light comes up. It took my heart out, you know? And I'm like, okay. So I pulled over, and then he says, your license plate is expired. Oh, I'm like, oh my God, when did that happen? I actually didn't know. And then he also went on to adding that, oh, it smells kind of like marijuana. I'm like, never in my life have I smoked cigar, never smoked marijuana. Where did you get that? So he didn't say anything about that. He just said, okay, well, I'll write you a ticket for your plate expired. So I went and immediately went online and renewed it, and it came in through the mail. So I have the renewed license plate now.
Okay, can you hold that registration up to the lens of your device? Closer? Closer, closer, closer. I'll tell you when to stop. All right, can you move it over to your left a little bit? Officer Carr, are you able to make this out?
He's got to say something so it gets big. The screen.
Oh, I'm sorry, hold on. Let me get the expiration date on it so you can, okay, here.
You say it slowly.
closer slowly.
Yeah, 11/22/23, yeah.
Fantastic. Is there a motion you wish the court to consider?
If he goes and puts that tab on his car, as soon as we're done, I would like to dismiss the ticket.
Okay. That sticker on there,
Yes.
the shiny thing. You need
Yes.
to go to the rear of the car and make
shiny
sure
part.
you get off the dust and dirt. Peel
Yes.
that off, stick it on there real good, work it over with your thumb a few times so it doesn't come off, and you're good to roll. So the officer's gonna take it on faith that as soon as you and I break off, you're gonna get out and do that.
It's in my house. I'm not even driving the vehicle because it was under my brother's name, so I left the car at the house. And
All
now
right,
I'm
now, get it taken care of straight away. And
Yes.
with that, there's a motion to dismiss. Please be careful in all respects when you're on the roadway. And there'll be no fine, no charge, no cost, no consequence. And the next time birthdays come around, we'll get on top of it, correct?
Yes, sir.
All
Thank you
right,
guys.
take care, sir.
You take care as well. Bye-bye.
Bye-bye.
Well, there you have it. We've got a disturbing trend. We've got a disturbing trend here of things not getting worse. That was the last second edition. It was kind of fun. It was kind of fun. I like that guy. He got his registration. He fixed it. Everyone was pulling for him. All is well in the world. Could I please stop butchering German names? Well, sure. As soon as someone tells me how to pronounce them right. I might need assistance with that endeavor. All right, there you go. Tons of fun stuff. Thanks to everyone as usual. I appreciate it. I will see you all soon.